Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 76. I'm going to take a slightly different approach to the podcast today as a result of a case decided earlier this week of PETA and EMC Corporation. This podcast is going to focus on one specific topic, namely the rules on where an employer who is located in one country is able to sue an employee who is located in a different country. However, some things remain the same, never fear, and as a reward for sticking with me to the end, I will share a couple of highlights from the recent Latitude festivals I went to, because I know you're dying to know. Anyway, I also start by saying my thanks in particular to Paul Goulding, QC, for sending through a copy of the decision, following on from a conversation he and I had about it only a couple of weeks ago, ahead of his arguing the case in the Court of Appeal. Indeed, I should say that Paul and Blackstone Chambers have written a very useful summary of the specific case, which is available on their website. However, I thought it might be helpful to focus an entire podcast episode on the approach to issues of jurisdiction in employment contract claims in England. I think this is a really key area for international employers. And interestingly, international employers will often have either common terms and conditions across a variety of jurisdictions, or may have common employment documents globally. As I shall explain in both the recent PETA case and in the previous Semengo-Turner case, the issue related to common bonus terms contained in a separate document, separate from the contract of employment, which was issued by the holding company to senior management of a particular level globally. And such documentation is, I have to say, pretty common. Therefore, the issue as to where any disputes have to be heard is a key one for both employers and employees, and may well determine the outcome of the dispute. So, the starting point is to establish the underlying rules on jurisdiction before considering how the English courts have actually applied them. Well, the starting point now is a regulation, a European regulation. It's Regulation 1215/2012 of the European Parliament and of the Council on jurisdiction and the recognition and enforcement of judgments. I'm just going to refer to it as the regulation. The general principle is that where a defendant is domiciled in a member state, i.e. signatory to this, it is to be sued in the courts of that particular member state. However, there are certain specific exclusions, and employment contracts are one of those special categories. Article 18 of the regulation provides that where an employee enters into an individual contract of employment, quote unquote, with an employer who is not domiciled in a member state, but the employer has a branch agency or other establishment in one of the member states, the employer shall, in disputes arising out of the operations of that branch agency or establishment, be deemed to be domiciled in the member state. So that's Article 18, deemed domicile. Under Article 21, an employer domiciled in a member state can be sued by its employee either in the member state where the employer is domiciled or in another member state in the courts for the place where the employee habitually carried out his work or in the courts at the last place where he did so. If there is no habitual place of work, then the employer can be sued in the courts of the member state where the business which engaged the employee is or was situated. So, in other words, the employee is given a choice. He or she can sue the employer either where the employer is domiciled or basically in the country where the employee worked. So that's the position if the employee is wanting to sue the employer. What about the more common situation, I suspect, where an employer wants to sue the employee? Well, that's provided for in Article 22. An employer may bring proceedings only in the courts of the member state in which the employee is domiciled. The only exception to this is the right to bring a counterclaim if the employee sues the employer in a different court. Under Article 23, the provisions of Article 22, the home rule, if you like, provisions for the employee, the provisions of Article 22 can only be departed from if it's an agreement entered into after the dispute has arisen, or it's an agreement allowing the employee to bring proceedings in courts in addition to those laid down by the regulation. So in a nutshell, if an employer, and we're going to look at that term, wants to sue an employee in relation to the individual contract of employment, and we're going to look at that term, then the employer, regardless of where it is domiciled, has to bring the claim in the member state where the employee is domiciled. Now, that at first blush may all sound relatively clear and comprehensible, and frankly it probably is, where both the employee and the employer are domiciled in member states. The employment provisions are in Section 5 of the regulations, and so from now on, if I refer to Section 5, that's the shorthand for saying the special provisions dealing with the employee jurisdiction in the regulations. Section 5. But what happens then if neither party to the litigation is domiciled in a member state? Well, the short answer in those circumstances, the English court will look to establish which jurisdiction has the strongest connection with the dispute, the forum conveniens principles. Now, I'm then going to deal in a second with the situation where the individual is domiciled in England and the employer is not domiciled in any member state. And both cases in England that have been reported in this area, the employer was domiciled in the United States, which is not a member state. However, just before we do that, it's also worth looking at what is meant by domicile, given that the relevant provisions only apply where a party is domiciled in the member state. Well, as a general rule, a party is domiciled in a jurisdiction, in the case of the individual, if he is resident there. And the circumstances of that residence support the fact that there is a substantial connection with the jurisdiction. A company is domiciled where it is registered or has a central administration, or where its principal place of business is. Well, under the previous version of the regulation, the regulation was silent as to what happened if the employer was not domiciled in a member state. This just wasn't mentioned at all. However, now there is a specific provision in Article 21 that states that an employer which is not domiciled in a member state may be sued in the court of the member state where the employee habitually carries out his work, or the last place where he did so, or courts in the place where the business which engaged the employee is or was situated. So, in effect, any employer can be sued by an employee in the member state where the employee works. That's the general thrust of that. I'm simplifying. There are some limited exceptions to this, but that's the general thrust of it. But what happens where an American company, say, which is not domiciled in the member state, sues an individual who is an employee domiciled in England, relying on an exclusive US jurisdiction clause contained in a document freely entered into by that individual, and in reliance on that clause, sues the employee in the US? Does the law say, well, the US isn't a member state and therefore the employer is not covered and therefore the employer can sue the employee in the US? Or does the law say the individual has got the right to be sued because the individual is domiciled in a member state? The individual has got the right to be sued in his or her own member state. Well, based on the two cases, the second of which, as I say, was decided this week, we now have a relatively clear understanding of how the Court of Appeal at least thinks we should approach matters. The Semengo-Turner case, the earlier case, was decided when the Article 21 (2) provision was not in the relevant regulations. That is, there was just no reference to the concept that an employer might not be domiciled in a member state. And 21.2, as I've mentioned before, is the provision that says if an employee wants to sue an employer, it doesn't matter if the employer is outside the member state. The Petter case was decided after the revised regulation had come into force, which they did on 10th January 2015. The starting point then, let's go back. Starting point is the case of Semengo-Turner and others, and J and H Marsh and McLennan Services Limited and others. The basic facts were that the employees were domiciled in England and employed by an English company. The English company formed part of the Marsh-McLennan Group, for which MMC is the holding company. And basically, and I'm summarising, the employees gave 6 months' notice in England to terminate their English contracts of employment to go and work for a competitor. They'd been the beneficiaries of a stock award plan which, in recognition of their potential for future contributions to the success of MMC, had given them certain significant benefits. And the bonus plan was, entirely understandably, subject to New York law and had an exclusive jurisdiction clause to that effect in New York, save for certain matters that are irrelevant at this stage of the summary. The individuals, therefore, were sued in New York by MMC and another US subsidiary company, relying on the jurisdiction clause contained in the document, and basically they were sued over certain covenants contained in the stock option document. The individuals retaliated and brought a claim in England for an anti-suit injunction. Essentially, this anti-suit injunction asked for the English courts to injunct MMC and the other MMC subsidiaries from pursuing the claim before the New York courts, saying, well, we've got a right to be sued in England, and that's not what you're doing. Well, the first thing the court had to do was to decide whether this was a matter relating to the claimant's individual contracts of employment. It was only if it related to the individual contracts of employment and that the dispute related to that the special provisions in Section 5 of the regulations applied. So, according in an earlier case, WPP Holdings Italy and Benatti, the Court of Appeal decided that the exclusive jurisdiction provision in question was not in a contract of employment, but was in a consultancy arrangement. As such, the provisions of Section 5 were not engaged, and the exclusive jurisdiction clause in the Benatti case was upheld. Well, in the Semengo-Turner case, the court decided that the documentation was entered into in connection with the individual's employment. It was in keeping with the provisions of Section 5 for this to be viewed as an employment dispute. It was reasonable to require all of the claims in relation to the dispute to be brought in one forum. Otherwise, Marsh Services Limited, the English employer, would have had to have sued in the English courts, whereas the American companies could sue in the New York courts. Therefore, this was a claim in connection with an individual contract of employment. Well, the Court of Appeal similarly took a wide approach in finding that, although technically neither of the two claimants in the US litigation, MMC and the subsidiary company, were in fact the precise employer of the individuals, that was the English service company, in reality the claim was being brought by the US companies to enforce employment obligations, and therefore in essence they were suing as the employer, even though they were not the party that had signed the precise contract of employment. So having established that this was a dispute about an individual contract of employment, and it was the employer in this wide sense that was suing, the court went ahead and decided to grant the anti-suit injunction. The court's logic was that the provision in Section 5 was there for the protection of the employee. It recognised the employee as usually in a weaker economic position when bargaining with the employer to negotiate documentation at the start of employment. If the anti-suit injunction was not granted, then in essence the employer would be deprived of his rights. So the choice was grant the injunction or do nothing, and so in the circumstances it was appropriate to grant the injunction. Well, following the decision, there was significant academic criticism of the Court of Appeal's decision. In particular, it was asserted that the regulation was designed to establish public rights between countries rather than private rights capable of being enforced by individuals. Secondly, some commentators asserted that the regulation does not apply to agreements which confer jurisdiction on non-member states, courts or tribunals. Well, since then, as I've mentioned, the regulations were amended, so we now have some provision expressly applying the regulation in circumstances where the employer is not domiciled in a member state, in terms of where they may be sued. It's still silent, however. It doesn't say specifically that an employer who is not domiciled in a member state can only bring proceedings against an employee who is domiciled in a member state in the courts of that particular member state. It just states boldly in the regulation, an employer may bring proceedings only in the court of the member state, etc., etc. Well, we have now had the follow-up case, which clarifies that the Court of Appeal is sticking to its guns. The facts were, depending on your point of view, either very similar or indistinguishable from the earlier Semengo-Turner case. Mr. Petter was employed by EMC Europe Limited. That's a subsidiary of EMC Corporation, an American company. Once again, there was a stock plan. Once again, the employee was sued in the US by the holding company in reliance on an express jurisdiction clause seeking to enforce post-termination restrictions and to rescind recent awards of stock. Well, the High Court judge was asked in England by the employee to grant an anti-suit injunction, but the High Court judge refused on the grounds that there was no reason to believe that the American court would pay any attention to the grant of such an injunction. I must make it clear, I'm summarising and very summarising significantly a rather longer decision because I want to focus on what the Court of Appeal did. Well, first of all, the Court of Appeal confirmed once again this was a dispute that engaged Section 5. In other words, although the party suing in the USA was not precisely the employer, and the document on which it was suing was not precisely the contract of employment itself, once again the Court of Appeal took a wider approach, wider than just looking at the precise contract of employment documentation and the precise identity of the specific employer. This was an employment dispute in reality, and therefore Section 5 was engaged. It was, as the Court of Appeal put it, quote, intrinsically bound up, unquote, with a contract of employment. Well, the Court of Appeal took the view that although the grant of an injunction was at the High Court's discretion, and the EMC's argument was that the judge's discretion not to grant the injunction should be respected, well, this argument was rejected. The Court of Appeal held discretion ought to be exercised in accordance with principles. Semengo-Turner was clear the choice was between doing nothing or granting an anti-suit injunction in these circumstances. The alleged unwillingness of the US holding company to respect the rights given to the employee, or the US court, to respect the rights given to the employee, was not a ground for distinguishing Semengo-Turner. On that basis, and in line with its earlier decision, the Court of Appeal granted the anti-suit injunction. So, where does this leave international groups which employ individuals in member states? Because, of course, as I've said, it's often quite common to find you have global bonus plans or stock plans, and some companies have gone down the route of having global contracts of employment, or certainly transnational contracts of employment, perhaps with a services company in one country employing people around the world. Well, first point to make is that many of the other member state jurisdictions do not recognise the existence of an anti-suit injunction. So this may therefore be a point which is particularly relevant to England and Wales and employees who are domiciled here. Secondly, given the much stricter approach to restrictive covenants and the general distaste in English courts for the equivalent of American pre-trial depositions, if the English courts have jurisdiction, this is likely to present particular problems for American employers seeking to enforce what I think are relatively standard clauses in stock plans. Well, at this point in time, so we have clear authority from the Court of Appeal that the courts are going to adopt a wide approach as to what constitutes a contract of employment. If the relevant document is entered into with a company within the employer's group and is entered into in connection with employment arrangements, then Section 5 is going to be engaged. At the moment, I don't think there's any clever drafting that will get around that particular problem in the real world. I'm assuming, of course, it's not commercially practical to have all senior employees operating as consultants, for example, mentioning the WPP exception earlier on. Well, so what are international employers to do? Well, first point is to recognise that many employees may not have the resources for the sort of litigation that is apparently continuing in the Petter case. Secondly, I think it's important that international employers do look at the realities of the situation. If post-termination restrictions are important to the international employer, then it's necessary to recognise that you may need to enforce them in the country where the employee is domiciled. As such, it may be necessary to adjust the standard covenants and provisions to provide some sort of adaptation for local nuances. MMC had actually done this in the Semengo-Turner case, but the restrictive covenant provisions were not the key provisions in question in front of the Court of Appeal. Thirdly, I think that if a situation arises where a company is looking to forfeit stock awards, etc., the existence of both the Semengo-Turner and the Petter cases does mean that employee advisors are going to be fairly clued up on the ways of challenging these forfeiture provisions. So, clearly, taking advice when drafting the rules of any such global stock plan may be essential, and, doubly certainly, before operating any forfeiture provisions or enforcing any restrictive covenants abroad, it may be very important to check the law of the country where the employee is domiciled. I understand that the Court of Appeal declined leave to appeal to the Supreme Court, and at the time of this recording this podcast, I'm not aware whether there may be an application for leave to go to the Supreme Court from the employer. So, as I hope you'll agree, that's an important issue and one which will affect most, I think, global employers, and certainly all those with common terms, conditions or stock plans, etc., across more than one jurisdiction. So, thank you for listening. I will, as I said in a second, I said at the start of this podcast, talk for a minute or two about the highlight from Latitude. I think apart from that, it just remains for me to say, as always, that the links to this will be posted out on Twitter, and I will post a link to the podcast itself. We're on YouTube, iTunes, and, of course, the Mayor Brown intranet. So Latitude, yes, Latitude was great fun. It was a really good time this year, and I went with David Reed, QC, as part of the Reed and Robertson Do Festivals tour. A particular highlight was he and I went and saw the Unthanks playing at a very small stage late one evening. And at the end of the session, the stage manager comes out and says, well, if you hang around 10, 15 minutes, we've got someone special coming in to do an unscheduled guest slot. So David and I shrugged our shoulders and thought, well, we haven't got anything else lined up, so we'll stay. And so about 30 seconds before the surprise guest hit the stage, the person standing next to me turned to me, I've never met him before, and said, "You'll never guess who it is. It's Ed Sheeran and Snow Patrol." So Ed Sheeran comes on stage. There are at maximum, I think, 200 people on this small stage, and does several songs, brings out several members of Snow Patrol, and they do a further song. And the bit that made me laugh, whether or not Ed Sheeran is your thing, it was pretty impressive to see one of the world's biggest stars that close, clearly having an absolute blast performing songs in this environment, and the crowd responding as you would expect. So I sent my wife a text saying, "You won't believe what I'm doing. I'm watching Ed Sheeran. It's amazing. I'm in a tent with only 200 people watching one of the world's largest stars playing." To which I got a response back from my wife, who doesn't come to festivals. "What a shame. He must be really disappointed." I was going, no, it's much more exclusive than that. So there you go. Highlight from Latitude. So thank you very much for listening. And I will be back with podcast 77. And we have a guest podcast, which I should just flag. We have a guest podcast coming up, which will come out in a couple of weeks' time on employment issues for employers with employing individuals in the Channel Islands. A really interesting guest podcast. And I learnt a lot during it. So, stay tuned for that as well. Thanks very much indeed.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email Nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.